Knows all kinds of crazy stuff.
Be stuffy.
Yeah. Hot in here today.
76 is hot. Okay.
It is. Now that it's getting cool outside, like I sleep with my window open, and it's amazing.
Yeah. Yep.
That and the jeans don't help much.
True. Agreed. You excited for the midterm?
So pumped. Is it this weekend or next? It's not this weekend, right? Yeah, weekend after that.
Right. Yeah, because next week Professor Ebart's going to go over review. Just to review. So any questions you have, obviously I can answer them, but if you want to spend the next week just reviewing everything that we've done so far and then come up with substantial questions, that would be pretty appropriate for next class, because that's the only thing on the agenda.
Okay, awesome.
How was that practice little question that Professor Burt gave you?
It was good. I just felt like I felt like I answered it too simply, I guess. But I guess there's not much. I mean,
Right.
there's really not a long, drawn-out way to answer those questions. Some of those questions.
Some of them you're right. Some of them are not. Some of them are pretty straightforward. Speaking of which, tonight's probably going to be pretty simple. Tonight's stuff is not really complicated, so we're probably getting exceptionally early.
I have no complaints.
Yeah. Yeah, I don't think anybody does.
Seven already.
I really hope though that I have as easy as a time as Professor Burt did, getting out of school like this and just opening up this for.
What's she on easy time?
Well, I mean, it seems like she did.
Yeah, I don't know if she worked somewhere for a while first or what her her setup was.
Yeah, because I thought she had said during one class, she's like, yeah, I didn't want to work for anybody else, so I just opened up my own thing. I'm like,
That's cool.
you get multi-million-dollar trusts in the States.
Do you want to do trust in the stakes? Who's trust in the stakes? Sheila Williams definitely did that basically, but she had a little bit of a simpler type of law, I mean, family law is more form-based,
Yeah. That's what I think. I don't know. I'd still rather find a firm that does family law at first. Only because I want to learn from someone before I go out there and completely fuck myself over.
It's a good idea, yeah.
And just have high malpractice insurance the rest of my life.
How are you with that kind of earnings? Still got 10 minutes. See, if she opened her firm in 2005, but became attorney in 2000, she had.
Oh, so she worked somewhere first.
She worked somewhere first. Which is just about the right amount of time, you know? So it'd be like 5 years somewhere and then
Really?
and peace out.
Did she say she was a real estate agent? I forget what she said.
I think she says.
I think she said something about real estate, right?
Yeah.
It's not funny, that's funny. Too funny. Sounds like lots of people are listening. Right.
All right, so Victor, I was telling the gentleman, this was a pretty easy section in the sense that there's not a whole lot they can test you on. It's going to be a will substitute. And it's pretty self-explanatory because you all have bank accounts, right? Like you've heard of life insurance. You know what retirement accounts are. You know what IRAs are, et cetera. So we'll probably leave somewhat earlier tonight. So basically, what is a will substitute? When we talk about will substitute, what's a will substitute? In a general, broad overview.
It's a way to dole out assets by means other than a will or a trust.
Right, so it's a way to distribute our assets without following the very formal, rigid requirements that we have for wills, right? So there's a lot of different ways of doing that. We have trusts, we have joint tenancy, we have community property, we have life insurance, we have IRA accounts, we have pension accounts, we have all of those things, which at the end of the class we'll go into more detail about all of them, and we'll do a sort of review as to what they all do and what we're looking for. But that's basically it, right? So if it's not a will, it's something else. Mm-hmm. And it's some way of transferring property without going through probate. That's not in a formal testamentary instrument, a will, or in following either a holographic will or a attested will. Okay, so who wants to take the first case? Farkas.
Okay. I'm trying to find my syllabus on my email so I know what page it starts on.
435. And I know you didn't read this probably very recently.
Oh, yeah.
Last week.
So I'll be kind.
Okay. So, in this case, this guy purchased some mutual bonds or some kind of stock option,
and for the payer of the bond, he put his name for the benefit, he put in the name of Albert B. Farkas as trustee for Richard J. Williams.
But did he have any trust?
He did not have a trust. He just wrote this as his intent to set up a trust. And so ultimately he died, but before he died, he had actually sent them in written instructions specifically stating that they were to be put, that he was to be trustee for this Mr. Williams.
And he basically sets up this very simple couple-page document trust for each of these certificates.
Yeah, and he does it multiple times. It's not like he just sent it in once, but each time he purchases it, he sends it in, and he sends in instructions that say, any cash that's created from them, I get. Any of the dividends or anything like that will go to him upon my death, and so on and so forth. Ultimately, he dies. His heirs contest it, saying that it really didn't mean anything. He didn't set up a trust. It's not in a will. It's not anything.
Mm-hmm.
So
one of the big contentions was it didn't follow any of the requirements for a will.
Yeah. The issue that I had was whether said trust instruments created valid inter vivos trust effective to give purported beneficiary willing title to stock in question after the death of settler trustee Farkas. And then the court, for their rules, said that in order to determine that, they have to consider whether upon execution of the so-called trust instrument, Mr. Williams acquired an interest in the subject matter of the trust, the stock, the defendant, Investor Mutual Inc., and 2, whether Farkas, the seller trustee, retained such control over the subject matter of the trust as to render said trust instruments attempted testamentary disposition. So they basically said that does the trustee, or does the successor trustee, does he have a vested interest in it? And then whether the trustor had such control over it as to be able to give it out and make the decision to give it out. Mm-hmm. And they said that in this case, he had the intent to put it into a trust. Mm-hmm. He funded the trust with these stock options, and that he had the capacity to do so.
Right. So this case, which is very different, and it was in 1955, and our trust law has completely changed since then. But this is the first time that they're actually saying trusts are going to be valid when there's a present interest transfer, which is actually the wrong result, right? Because it wasn't a present interest transfer. Technically, he could have gone back to those stock certificates at any time and changed that. Mm-hmm. But the court really wanted to side with this guy. And so the court says if there's a present interest transferred, then I don't have to follow the statute of wills. I don't have to follow the formal requirements of constructing a will, and this is something else entirely. Because it's something else entirely, we're going to let it go. So correct result, probably incorrect reasoning. But again, in 1955, they didn't have the Uniform Trust Code. They didn't have all these other laws, and they didn't have a wave of people wanting to build trusts at that time. That came later, around 60s and 70s. So correct result, but this is where we're going to talk about, and you see it further in the materials, is what's the present interest. So it's present interest transfer. Now, you may get something that looks like some sort of contract on the bar exam, and it may not fit in any of the regular categories. It may not be a will. It may not be life insurance. It may not be a retirement plan. It may not be anything else that sort of fits in a normal rubric for you. But you can use some of these principles if a present interest is transferred. So if a present interest is transferred, then we use the donor's donative intent. So it's not necessarily a testamentary instrument, but we're going to allow him or her to transfer that asset however he wants if there's a present interest transfer. So that's a little nuanced. Now we're going to juxtapose that with the next case, which is the moon case. Who wants to take the moon case? The airport.
Okay, so this is regarding the trust of Mr. Lessiker. Mm-hmm. He had 10,000 shares of stock that he put in the trust, and then he went ahead later on, and then they go through the terms of the trust, and he goes ahead and sells them for like $2,000 and takes on his taxes like an enormous loss.
But where does he sell them to? Who buys them? Another trust.
Okay, I get the S&S trust? Okay. And then, at the end, they're wondering whether or not he had the ability just to transfer this away like that. And, they said that he did, because, yeah, I mean,
So does that daughter have standing to
no,
pretty much say to dad, you made a bad decision, you can't possibly have sold this for $2,000?
no, he can sell it
And why can't he sell it?
because he put it in the trust, he's still alive.
Yeah, he's not alive now, but at the time he was alive.
Right, he took it out when he was alive. Right.
And what was the power in the trust that gives him the ability to do that?
Being the trustee? Co-trustee, I guess, in this case?
No, he's the trustor.
Trustor, okay.
So because he's the trustor, he has the power to amend the trust, which means he has the power to divest the trust of assets. Whether or not he makes a financial move that's smart or not smart, oh well. So dear daughter, you don't have the ability to object when I have a trust and it's revocable during my lifetime, and I do whatever the heck I want with it. So if you're the trustor and your trust is revocable, you have a pretty broad range of powers that are going to allow you to do pretty much anything. And we're going to almost always side with that trustor, that settlor, that grantor. Remember, all those terms are the same. So that's what the court said. The court said, well, sorry, daughter, you don't have any standing because dad could do whatever he wanted when he was alive. And because he could do whatever he wanted, he could divest the 2,000 or the 10,000 shares for the sum of $2,000 and put it anywhere he wanted. Okay? So this is now looking more like the correct result in terms of trust. We're going to side with people who make trust, not because there's a present interest transfer, because that's not what the court said here. The court didn't say that there was a present interest transferred to either of the beneficiaries, either of those children. The court said, well, hey, settlor retains all his rights, he can do whatever he wants. So because he retains all his rights, whatever happens during his life, you don't have the ability to object to that. He's competent. There was no evidence that he was incompetent, right? Those are some of the questions we can get to later. There's no evidence that there was some third-party trustee that was influencing him. He's the settlor. He's the trustee. He's competent. Broad range of powers means that we're pretty much going to let you do whatever you want with it.
So in that case, I have a question. Was she trying to recover from? Was she trying to recover from the person who bought the shares?
Right, so it's a different trust. So she's trying to recover from the people under the S&S trust. Because they're now the owners of those shares. If those shares were properly vested in this new trust. So she's trying to invalidate that transaction, that transfer. Okay? But court says, sorry, you don't even have standing. So whether or not that was valid or not is irrespective of our question. Our question is you don't have the power to bring that suit. Right? Okay. What about our lovely Patterson?
Patterson?
Mm-hmm.
So here we have Darlene Patterson. She had made her trust. And it was all set. Well, her son, also Patterson, was going to get a share. But then before she died, she added an amendment to the trust saying he gets nothing.
Mm-hmm.
So now after she passed away, he's saying, well, we should invalidate this amendment because it goes against what the trust says. And he said, well, because of her intent was to divest you, and then we're going to go with that. So the son got nothing.
Mm-hmm. So the question here was, she made this amendment, but did she properly do the amendment?
I don't think she did because she didn't really have a
Delivery.
Delivery, exactly.
Right. So the court, the problem here was that she might have made this amendment, but it wasn't, quote, delivered to the trustee. But the Uniform Trust Code says that if there's clear and convincing evidence of your intent, of which there is, she had an amendment. The amendment was pretty clear. It basically said, yeah, I'm disinheriting one son because I've provided for him during my life in a fashion of which was, acceptable to me. But even though she didn't follow the strict rules in the trust as to how to amend the trust, courts are going to say, that's okay, you basically followed it, and there's clear and convincing evidence as to what your intent was. So the courts are becoming more and more forgiving for trust instruments, and they're becoming more and more forgiving for trustors. And they want to give flexibility to trustors in order to amend their trust in any which way that they want. Almost every single trust that you're ever going to read is going to have some language that says, anything that needs to amend it must be signed by the trustor and delivered to the trustee. It's just standard language. But does it really matter?
Well, at the same time, like they said in the Moon case, because that was one of the issues I thought in the Moon case too, is that at that time when she's amending it, the trustor and the trustee are the same person.
Exactly.
So she doesn't have to give notice to herself.
Right.
Because she's just doing it herself.
It's an arbitrary requirement. But then the question becomes, what if you're not the trustee? Right? Is that going to be sufficient? What if the person's incapacitated? That's never going to be sufficient. But if you're remember, if you're the trustee and you're the trustor and you're one and the same, the courts are going to give you a lot of broad powers, and they're going to give you a lot of flexibility as to what you can or can't do with your documents. Okay? So, of course, again, you want to be those two people the same because you have outside people, third-party people involved, you're going to have a different set of circumstances. Okay? What about the State Street Bank?
So in this case, Mr. Dunavere, he created his trust. He put everything that he owned in trust, and he eventually went to get a loan for $75,000. And when he met with the bank, he said, "Oh, I have plenty of stuff," and everything that he rattled off, he said that he owned, but in fact, it was actually owned by the trust and not by the guy himself. But he never told the loan officer that. So the loan officer eventually gave him the unsecured loan for the $75,000 that he had asked for. Unfortunately, 4 months after he borrowed the money, he died. And the bank wanted to go in to the trust and take the $75,000 because he did not have enough left in his residuary estate to take from. And the beneficiaries objected, saying, "No, it's in a trust. It's no longer his. It's ours now." And so the court had to decide whether a creditor can go into an inter vivos trust where the trustor and the trustee were the same person at life, and whether they can still go in and take debts that are owed by the trustor. And in this case, they said that where a person places property in a trust and reserves the right to amend or revoke or to direct disposition of principal and income, the settler's creditors may, following the death of the settler, reach in satisfaction of the settler's debts to them to the extent not satisfied by the settler's estate, those assets owned by the trust over which the settler had such control at the time of his death as would have enabled the settler to use the trust assets for his own benefit. They said as long as you retain control over the trust assets and your trustor and trustee, creditors can go in and take it when you die.
Yeah, and that's the correct result, right? I mean, if it's your money, you just have a different word on the bank account, so you have the word trust on it. You shouldn't be able to then hide those assets from your creditors, right? So this is a correct result. The court's got it right, even in 1979. Now, the way this will fundamentally work in California is slightly different. So in California, you're going to need to present a creditor's claim. You have the right, we talked about this earlier, but you have the right under a probate estate to open a probate if you're a creditor. You file a creditor's claim in a probate estate, and the probate estate may have zero assets because everything may be in a trust. But you file your creditor's claim in the probate, there's no assets in the probate, so then you now take your claim against a trust. So you can do this in California, it just looks a little different. A creditor wouldn't be suing the beneficiaries of a trust in this way. But correct me though, you can't use a revocable trust to, you know, hide assets from your creditors. Now, is there any other trust you could use to do that?
Irrevocable.
Right? But what's an irrevocable trust?
Basically, it's just there and you can't touch it.
Right, and you don't have powers.
Yeah, you don't.
So you've now lost your ability to have these retained powers to change it, to use it, to divest the trust of the assets. Most of those powers no longer exist. It is an irrevocable trust. So then it's a shift. So if we vested it into an irrevocable trust, bank might have had a much harder time getting it. Now, in California, we don't like what's called credit shelter trusts. So that's when you fund a whole bunch of assets into a trust because you have all these creditors knocking on your door and you just don't want to pay them. It's frowned upon in California. We don't allow them by practice. And most of the time when people set them up and you can find out that that's the reason why they set them up, the courts are going to pierce them. And the courts are going to be able to go in there and give assets from those trusted creditors. Okay? But here the goal is, and the takeaway is, it's an irrevocable trust. Grantor had rights during his life. He could do whatever he wanted with them. It's as if he just owned them. They were just vested, entitled a different way. So dear creditors, if you want to go after those assets, you certainly can. Now, what are some assets that a creditor can't get?
Like trust assets or?
No, other assets. Like I
Life
die and I
insurance?
have. Right, life insurance is one of them.
I think the book mentioned when is it like a joint ownership account?
On certain occasions, retirement benefits, those are all outside of a creditor's reach. Now, that's because it's harder to funnel assets in there, right? I mean, you're only entitled to whatever your policy premiums are for your life insurance. So you're not going to be able to then go put your $400,000 in a life insurance policy. It doesn't work like that, right? It's planned, it's an annuity, it's a policy agreement. So some assets you can escape creditors, like those. Retirement, beneficiary designated accounts that are not bank accounts, for instance. Something that has some sort of mechanism or scheme built into them that will take it away from an estate. Okay. What about the Mayo case? Well, I don't know these divorce cases.
Yes, the divorce. So, a woman was a professor of psychology at Boston University. She executed a will, naming her husband the primary beneficiary. She had a retirement plan in this, and then she executed another will in '73 where she poured everything over and set up her nieces as beneficiaries, or as residual beneficiaries, I believe. And so in this way, she locked everything tight. And then in 1978, she got divorced. She changed the beneficiary designation of her life insurance, but she left the pension plan's beneficiary just didn't change it. And so the question is whether or not this should have been revoked on divorce. Now, it looks like it's part of the policy of the state of Massachusetts because they go into what would happen if it was a will. And they said, under a will, it would be revoked on the divorce.
Because there's a specific statute that addresses that.
Correct. And so they said the same thing should happen in this trust, that it should have been revoked on the divorce.
Right, so they're making the analogy that at this point, in the 80s, 1985 here, the courts again are moving towards the favoring of trusts, and they're making the analogy that a trust and a will do virtually the same thing, although they're called very different things, and it's part of an overall scheme, it's part of an overall estate plan. So even though our statute talking about revocation on divorce doesn't address the word trust, we're going to make the analogy that whatever they needed to use in terms of revocation on divorce for a will is going to be applied to trust. Because it's virtually the same type of an instrument, right? This is a revocable trust. Wife was using it to pass assets on her death. Same as what we would do for a will. So this is where we see that now revocation on divorce is becoming more and more favorable, and it's being used with trust, even though statutes are lagging behind and not using those words in their statutes. So revocation on divorce, we have one in California. It is 50/40, probate code 50/40. And basically it says, you know, any sort of joint assets, other assets that you have with your spouse, upon divorce, those are deemed as though that spouse is predeceased you. So they can't inherit. That's a good thing, right? That's a public policy argument that's probably very appropriate. As they say in a lot of these cases, most of these testators, settlers, grantors, are not that sophisticated. They may not know how to change these things. They may not know how to go back in and change a life insurance policy, beneficiary designation. You know, they might have set that up when they first got hired, HR did it for them, and then they never thought about it again. So revocation on divorce is a really, really appropriate and good public policy statute that helps to make sure that people aren't unjustly enriched, right? Because if you get divorced, the presumption is that you don't really want to give that person much in your estate plan, right? And that's irrespective of whether or not there's a marital settlement agreement. So this is a greater level of protection for the testator because it's already in the statute, irrespective of what your marital settlement agreement says or doesn't say, right?
Is that true, like, even for, like, non-marriages? So, say you put, like, fiancé on there, you're not married, but you break up, you're technically not a spouse, and you just forget to take them off or whatever.
No.
So it would still go to them, they're not revoked?
Still go to them. Because then where do we draw that line? I mean, how can we cut that off?
Yeah.
You know, marriage is a very definitive, finite thing. And there's a way to get married and there's a way to get divorced. And they're very, very succinct and they're statutorily authorized, right? Relationships come and go. If you're making a present gift like our two little Argentinians later, you know, if you're making a gift, that's on you. You know, because you also knew that you didn't have the protections of marriage when you made that gift, right? Because also remember, marriage has a lot more than just pen and paper. You have marital deductions. Any amount of gift you give your spouse, it's free and clear. You never have to worry about it. There's a marital deduction there. There's not one for girlfriend, boyfriend, right? Or significant other, or partner, or what have you. Those don't exist. So we still hold marriage up to a much greater standard than we do any other types of relationships. So good question, but no, you can't have revocation on breakup. Okay. Oh, little review. What's redemption?
Redemption is where you no longer have it in your estate.
That's right. What's abatement?
It's where you do not have enough in your estate.
Correct. Right. So those are two that always get confusing because you read them and they sound the same. And it's very frequent that we'll switch what their definitions are. So again, redemption, Rolls Royce I give to my son Joe. I don't have a Rolls Royce for my daughter. Too bad, Joe.
That's too Joe.
Okay. Abatement is I give $50,000 to my daughter, I give $50,000 to my son, and I give $50,000 to my niece. But my entire estate only has $100,000. Everybody comes down, right? Everybody has a pro rata share that they're going to be reducted for. Their shares are going to be abated. Okay.
You don't want to do that even if I don't have the luxury cars, just give them away.
Yeah.
You get my Tesla, you get my Rolls Royce, you get my Corvette. Go buy them.
Unfortunately, that leads to a lot of complications and litigation. Because then you have all these beneficiaries that say, well, he must have owned it. I'm gonna go look for it. And you're like, bank account says zero. There's not $9 million. Go for it.
It said zero because he bought all these cars. I know. Here's your Corvette.
But then if you have that case, what would something that, if that was on your bar, so if that was, you know, a guy who lived in the slums, let's say, had all these extravagant specific bequests in his will. What's something that you would think, Okay, well, what's going on there? What was going on with him?
That he didn't have the requisite intent to create the will.
Right, but what does that also mean? Maybe he lacked
Mental capacity.
Capacity.
right? So if you're making all this weird distribution provisions in your will, maybe you didn't know what you were talking about, right? So always look to that too. Might be a capacity issue. Might have been inflated ego, but that also might be capacity, right?
One day I have this, so I'm gonna give it away now.
Yeah, maybe it's a person.
We, Professor Eborb actually has a case like that right now. Guy inflated himself ridiculously, told everyone he was worth millions, and died with a couple thousand in his bank account. And so now all these people who had been the beneficiaries of these wonderful tales are shocked. And now they're fighting because they can't possibly believe that he didn't have all these assets.
People are crazy.
Now, he was dating a porn star, and there was a lot more other things, so perhaps he needed an inflated ego for other reasons. But anyway, the point is that it does happen, but it just leads to ambiguity and questions about testamentary capacity. All right, what about Cook and the life insurance?
Okay, so we have here, husband and ex-wife, while they were married, they, because he put a lot of stuff in her name as the beneficiary. And then they divorced, and husband now has a wife and a child, but he didn't change everything out from his ex-wife's being a beneficiary. So now that he's before he died, he made a will saying, "I leave everything to my wife and son."
Mhm.
But once he died, the ex-wife still got whatever was in her name. I think it was the insurance policy that was in her
Life
name.
insurance, yeah.
Life insurance policy. And now the new wife and son are like appealing, well, why'd she get that? It wasn't his intent, you know. But then the court said, well, yeah, but he had a really long time to change it. He didn't do it. And then the policy is pretty clear as who it goes. There's really no issue of facts here, so they kind of give the policy to the ex-wife, and the mother and son got nothing from
Mm-hmm. So he's trying to change it.
that. That's it.
His holographic instrument attempts to change it. He even mentions it. I mean, so it's pretty clear he's talking about it, he wanted to change it, but he didn't follow the precise requirements in the policy of the Equitable Life Assurance Society. They had very strict requirements as to how you can actually change beneficiary designations. He didn't follow them, and so then first wife, ex-wife gets everything. So how do we reconcile that with revocation of divorce?
Yeah, how?
You don't.
Well, I mean, here-
It's not a will, it's not a trust, it's, you need to take them out, right?
Well, but our statute is pretty broad in California.
Well, in California, it would have been a different finding,
Right.
right?
So in California, under our pretty broad revocation on divorce, it's unlikely that first wife would have gotten it.
Even with the amount of time that had passed between,
We're pretty clear.
and him obviously knowing that it was there, and
If you get divorced, you get divorced. Absent some other testamentary intent showing that you wanted her to get it.
so you
This is
redid it
not-
after the divorce and still listed them.
Yeah, exactly. And that does happen. But no, that wouldn't have worked here. Presumably that wouldn't have worked here because they would have used that statute, and they would have said, well, wait a minute. There's a statute that says it. Now, what if they weren't married? What if it was just a girlfriend?
Well, then there's no revocation upon breaking up. So
Right. So under that theory, if they were just, partners in a relationship, there's no statute that gives some sort of equitable public policy relief to that person. So better follow those requirements, right? So when you look at questions on the bar, they're gonna say something like that. Wrote a new beneficiary designation, but the beneficiary designation was never filed with the company. The beneficiary designation was never received by the company. The beneficiary designation wasn't on the company's form. All of those things, they're trying to get you to realize that there's some sort of conflict now between what's actually the designated beneficiary according to the plan policy and what is the statute of wills and or other public policy requirements saying for a donative intent. And one of the things you can think of is revocation on divorce, right? If you're divorced, out. If you're not, okay. Now, there's a caveat, and we're going to get to that in 2 more cases with respect to federal programs. And that's not going to give the right result.
But so say you did send it in and they just never received it, and you substantially complied, they just didn't receive it and you died. I mean, is there like a substantial compliance test type thing to where you've done as much as you possibly could, they just never got it?
Well,
Granted, if they never got it, then you don't know that it's out there, but
right.
unless you make a copy of it and have like sent on or.
Yeah, so there might have been a public policy argument under that that said, okay, look, he did everything he was supposed to do. Just because you lost it, or you changed your computer systems and it wasn't filed correctly, or a litany of other things. Yeah, that might have worked. But you'd have to have some pretty clear facts that say this was the requirement set out in the policy or the institution, and we followed every single one and it wasn't my fault.
Mm-hmm.
Unlikely. Because nobody ever follows the rules in bar questions, right?
Sure.
Okay, what about our lovely Newderman?
So in this case, Mr. Grubbs had an IRA.
What a great name.
He left his IRA to a Janine Noonan, and ultimately he got sick. He summoned a lawyer to the hospital, and the lawyer created his last will, and it said, I leave, it said in really simplistic terms, basically, I leave everything of my estate known and unknown to my mother. Mm-hmm. Unfortunately, it did not mention the IRA, and so the mother sued to freeze the transfer of the assets from the IRA to Mrs. Noonan, stating that his last will and testament was actually the change of the beneficiary form.
What about this note?
There was also a note found that was basically a holographic will that basically said, I leave all of my estate and the IRA to my mom.
But when was that drafted?
That was drafted before
the attorney document.
The attorney one.
Mm-hmm.
So the argument is that in Arkansas there was a statute that it says when it comes to a life insurance policy, you have to follow the letters to a T, unless there is a will that specifically names it and changes the beneficiary through that will. Mm-hmm. Here they said that the last will that was drawn up by the attorney didn't mention it, therefore it doesn't flow to change the beneficiary name on the IRA.
On that document.
On that document. And then when they looked at the holographic will that was found in the Bible, they said that
always find in the Bible.
They couldn't trust it because it was found by the mother after he had died, and she said that she found it in the presence of a coworker, and the coworker said he never saw her find it and she never brought it up to him. Mm-hmm. So they said, had that will initially revoked the beneficiary, and then the lawyer's will would have encompassed the IRA from the holographic will into the new will as part of his estate, then she would have gotten it. But since they can't trust her and trust the holographic will, they're going off of the lawyer's will, which doesn't mention the IRA, and therefore Mrs. Noonan gets the IRA.
Right, and unfortunately for her, the will said revoking all other wills and codicils at any time heretofore made by me. So even if it was valid, even if that note in the Bible was valid, doesn't matter. Subsequent will revoked it.
But so my question is, the holographic will would have changed the beneficiary under the Arkansas statute.
If they had stopped there, yes.
But so doesn't that then nullify Noonan's claim to it and it just becomes part of the residuary?
No, why?
Because I figured how does the beneficiary get added back on after it's been revoked by a will?
Because that beneficiary still stands. You can only change it by a will. So if I change it by a will, but this will is wrong, then that beneficiary this beneficiary is still there. The beneficiary designation is still there. I only changed it by virtue of this document. This document is now invalid. So every part of this document is invalid.
Oh.
So
But say it was valid. Say it was valid and it got revoked by this
yes.
other will.
Mm-hmm.
Would it go back to Mrs. Noonan then? Or would it then become part of the residuary because...
Beneficiary designation is still there. Because holographic will's here.
Mm-hmm.
Holographic specifically states it, and there's a statute that says you can change it with a will.
Mm-hmm.
Great, fine. New will now revokes all prior wills.
Mm-hmm.
So now that will that existed is out.
Well, wouldn't the holographic will revoke the beneficiary status of Mrs. Noonan?
It doesn't revoke it, it changes it.
But then how does she get added back on by the cancellation of that will?
Because she was always on to begin with. I only amended it, and if that amendment is invalid, my original document, my original designation still stands. So I didn't revoke this. It's not that I'm revoking the beneficiary designation, because that's a good point. If I revoke the beneficiary designation, it goes back to 0.
But don't you revoke it by naming a new one?
No, you're amending it. You have to think about it that way. You're amending it because you're never going to have to be able, with a new document,
Mm-hmm.
like a new will, if a statute allows it here,
Mm-hmm.
you're just changing it.
Mm-hmm.
It still exists.
Okay. So she's still there, but the will just kind of puts her over it.
Correct.
And then as soon as that will's revoked by
She's
either another will or because it's deemed invalid, then her name just falls off and
She's still
the
there.
original one stays on?
Original will is always there.
Okay. Unless you physically revoke their beneficiary status.
Correct. If the person had gone in and sent in an actual change of beneficiary, that's revoking a prior beneficiary. That's now no beneficiary will ever, that first beneficiary is completely out of the picture entirely.
Okay.
And there's no way to re-put them back in, revest their rights unless you do another beneficiary designation. Or a will that amends the beneficiary designation.
And is that true in California as well? A will can change the beneficiary designation on a life insurance driver?
Not usually,
Okay.
because there's a lot of companies have their own strict requirements, and we want to give companies the ability to act independently from our probated states.
Mm-hmm.
So you got to follow the requirements.
Okay.
Same with a retirement account. Okay. Okay, so now we get to go to our URSA case. And do we all know what URSA is?
Early. It's the Employee Retirement Income Security Act of 1971.
Yes, that's what the acronym stands for. But basically what this is it's the law that governs retirement, pensions, other accounts, life insurance built into retirement accounts that are on the federal level. Right? So if you ever work for a federal government in any capacity, you will have an URSA protected plan. That's not to say that there are other plans that aren't also under URSA. There are. You can have you can work for a private company, but it might be under an URSA plan because it's under a federal jurisdiction. Because I have let's say AT&T, for example, not that they're going to have pensions anymore, but let's say that they're working all over the United States. So they're going to be governed under federal law because they work in all the United States, right? If you have some sort of small mom and pop shop in Palm Desert, for example, and they happen to have some sort of pension, it might not be falling under the URSA program. But 9 times out of 10, your major pensions are going to be falling under URSA. Okay? All right, so now go ahead with our lovely.
Okay. So in this case, we have a married couple named David and Donna, and she is his
Wife.
Well, right, I just said that, but, so, she's his designated beneficiary, and then they get divorced.
Yeah.
So the question is, where does this, insurance proceeds go, and these, Boeing company, whatever. But so the children are the respondents in this, from a previous marriage. They would be his heirs intestate.
Again, code word, they're always gonna be blended families. Nobody's ever gonna have the same children.
Okay. So the idea is whether or not, under URSA, the Washington state, rule applies that would, revoke her, and give it to the children, because they're his heirs intestate. There's the court split on it. Clarence Thomas writes for the majority, and he says that first of all, this is going to preempt, and we need to have consistency across all the states regarding all of this. And so they gave it to the wife, essentially, so it doesn't apply. There's no federal rule on this. Breyer dissented, thinking that it's really not a big deal if it gets applied differently in different states.
And unfortunately, that's still a law.
Okay.
So URSA is a federal statute. So it doesn't matter what my California probate code says. Federal law is going to preempt it, and I don't have to follow it. Not the right result, right? Especially in certain of these cases, and I think this is one of which the testator, the decedent, lived in Washington, always lived in Washington, abided by Washington, paid Washington taxes, was a resident of Washington his whole life. So why wouldn't a Washington statute, of which he would have been fully aware of and would have been mandated to follow, why wouldn't that be appropriate here? And the simple answer is it's a federal statute. URSA is a federal statute. Still happens today. So in California, same result would have happened. Even though we also have a revocation on death, or excuse me, revocation on divorce, same result applies. URSA's gonna win. Great, now we get to go to our Argentinians.
This is Valeria versus Martin. No, also trying this one. Unless you took the money and everything.
Oh, don't skip to the good part.
Oh, okay. I'm trying to remember the details.
Anybody want to help?
Do you want to do the next one?
Yeah, I'll do the next one.
Alright. So basically, this guy's a steezy lawyer.
Oh, we don't know that.
So he was an Argentinian lawyer, and she was his side piece. He was married. She was living with him in their I think they were in Argentina.
No, it was Florida.
Were they in Florida?
Mm-hmm.
Oh, yeah, I have to be in Florida. So they were in Florida. She was living in the condo with him as his mistress while he was married and had kids somewhere else. And he decided that he was going to put her on his Merrill Lynch account and give her a debit card to it.
Mm-hmm.
And when he did it, they went in there and they talked with the account representative, and they're like, if you're putting her on as a joint owner and giving her a debit card, she has access to everything. And they went over everything in English and Spanish. He agreed to it all. She had the check card and everything was fine until he had a heart attack. He had a heart attack. She called 911. He went to the hospital. She stayed with him. She called his daughters. The daughters told her to get the hell out, basically. Mm-hmm. So when she did that, she went to the bank and
on her way out the door.
Yeah, on the way out the door, she went into the bank and took $280,000. $280,000 out of the account. Mm-hmm. And the bank where she went actually called the home branch and said, is she okay to do this?
Yeah. Mhm.
They're like, oh yeah, sure. No, she's joint owner. She can do whatever she wants.
Yep.
And so she put it into her own Merrill Lynch account. So he gets out of the hospital. He survives. He calls her back and says, I want my $280,000 back.
And she
says, no.
Mhm.
He calls Merrill Lynch. Merrill Lynch actually gives him the money back. So then Merrill Lynch goes after.
By the way, that's not going to happen
No.
now.
Merrill Lynch then goes after her, saying, okay, give us back the $280,000. She says, no, it's mine. The trial court found that the guy was the sole owner, and because he lacked the donative intent when he added her as a joint account owner. The court basically found, though, that when you enter into a joint account, you are giving joint ownership to everything that is within that account to that other person, whether you intend it or not. That is the whole purpose of putting somebody on as a joint owner. And they said here, he can't even plead that he didn't know because A, he's an attorney, B, it got told to him in English and Spanish, and C, he gave her checks to it and said, he gave her the
debit card.
He gave her the check card,
Yeah.
but said she doesn't have the ability to write checks off this account. And the court basically said the whole point of a debit card is to replace checks in society. So if you're giving her a debit card, you're giving her access to checks.
Right.
So sorry, you lost your money.
Yeah. Interestingly enough, however, the court requires her to pay back 50% because the court says that she's entitled to half of the $280,000 because it's a 50-50 ownership, which is a very odd result because who knows what was the balance in the account? We don't know. There probably was more than $280,000 back in the balance of the account, but we don't have that information. So this is, again, going back to what we said at the very beginning of the evening, present interest, right? It's a present gift was established. The minute he added her to that account, he gifted her portions of that account, right? So it was a present gift established when he added her as a joint account owner. He didn't add her as a POA. He didn't add her as a POD. He didn't add her as some sort of beneficiary. No, he added her as an owner. So you can't go and cry and say, oh, woe is me, my girlfriend took all my money, when you put girlfriend on your account. Right? That's what this one stands for.
And then I know in the white book, when it goes into the joint account, it talks about the whole rule about you can't take out more than what you put in or something like that.
Mm-hmm.
Is that applicable or no? Because most institutions have their own, it's a joint account, so you get whatever's in that.
Exactly. So most institutions are not going to make that distinction. Now, you could make that distinction in court. You could say, well, wait a minute. You know, there's proof of what went in. It wasn't just, oh, like in this case, he already had all the money, he added her to it. That's a gift.
Mm-hmm.
That's unequivocally a gift. Because obviously, she didn't put it in. On those cases, on another case, when you're establishing an account and you come to the table with this and you come to the table with that, that's pretty clear. We can trace those assets.
Mm.
Okay. So it's a better argument to make there.
Okay.
This is a different situation because there's no evidence that she put a dime in there, right?
Okay.
Okay, what about our last case?
Correlator.
In my area.
Okay, so in this case, we have a gentleman who married this lady Martina and gave her power of attorney to do all sorts of stuff.
Mm-hmm.
But the power of attorney kind of limited some things. There's some limitations. You can't like gift more than $10,000 a year. But she used this power of attorney to give herself Vivo's trust.
Well, it wasn't her trust, but
It wasn't her trust.
it was in his name. Uh-huh.
It wasn't his name. But then she made this trust where she transferred a property into it that gave herself life estate and pretty much power to do whatever she wanted with the stuff she put into this trust.
Mm-hmm.
And then upon the gentleman's death, the kids were saying, well, her power of attorney didn't really give her the power to create a trust.
Mm-hmm.
Can't create the trust, and then you violated the gift was a breach of fiduciary duty.
Mm-hmm.
And then the courts found for the children saying, oh, you're right, you can't just go make a trust for this guy using his power of attorney.
Okay. So yeah, the daughters, I think they're daughters, the children were saying, well, wait a minute, this is obviously a breach of some sort of fiduciary duty. There's no, how can this person possibly set up something that has such self-dealing? But then they go back, right? And they go back to the trial court and they look back in the records, and he actually had drafted documents to this exact effect. And what they did is the lower courts were using the power of attorney, and the power of attorney had some pretty broad language. The power of attorney had said something to the effect of, can do anything with respect to property that the trustor or the principal in this case would have done. So that was a really broad interpretation. Now, the beneficiary said, well, wait a minute, that's way too broad. You can't, that's against public policy to make it so broad that you could do anything you possibly want with something. That's something that one person would intend to do. So the courts did say, no, you can't use the power of attorney to do that. Now, in California, our power of attorney statutes, you have to specifically say in your power of attorney that the agent, who is the person who can make decisions on your behalf, you're called the principal if you make a power of attorney. The agent can set up a trust, but you have to specifically give them the power to create testamentary instruments. In the same way, you have to specifically state that an agent can make changes to beneficiary documents, beneficiary designations.
I thought in this case they let her change the trust.
They let her change it because it says when the principal expressly granted his attorney, in fact, the power to convey realty from his estate, he must have anticipated that the terms of his will might so be altered. And it's not clear then why conveyance of Clearwater to a trust would be per se impermissible alteration of the will when the power of attorney expressly authorized Martina to convey any real estate outright to others. And they only remanded it back because they had to find out whether it was a breach of fiduciary duty, because they never got that far.
Right.
But they said that she could do it.
Well, and I think that's because they were saying that the power of attorney was so very broad.
Yeah.
But again, when they did remand it, they looked back into the records and they realized that this guy had already started all these documents that were in conjunction and followed pretty much precisely what she was trying to accomplish. So that was she wasn't doing anything nefarious. But in California, again, you have to have specific language that gives somebody the ability to set these up. Okay. Now, what's a durable power of attorney?
Durable power of attorney is surviving capacity, right?
Correct.
Yes.
A durable power of attorney survives your incapacity. An ordinary power of attorney does not. So an ordinary power of attorney is used until you're declared incapacitated, and then it ceases to have any validity, which makes absolutely no sense. Because why in the world would you want a document to stop working the minute you need it the most? But that's why most of the time in our common language and our general practice, everything you do is just about durable power of attorney. But if it doesn't say the word durable, the minute somebody is declared incapacitated in your fact pattern, you can't use it anymore. What's a healthcare directive?
That's the paperwork the hospital follows. You give the power over health decisions in the hospital.
Right, so you're nominating an agent to make healthcare decisions for you, to direct the disposition of your remains, to discuss HIPAA-related information, to get access to HIPAA-related records, and can pretty much do or say whatever they want with respect to your body and your health. That's what a healthcare directive is. Same word is used for a living will. It's the same document. It's an antiquated term. Living will has absolutely nothing to do with a will. It's a healthcare directive. Okay. Okay, so now let's do some overview of what are these will substitutes. So we talked about trusts. Trusts are will substitutes because they function in the same way that a will does. You hold assets, the trust dictates what happens when the assets, when you're no longer with us, so it dictates the distribution of assets upon death. Life insurance, same way. Life insurance has a beneficiary designation that goes outside of probate. That functions as a substitute for anything in your will. Pension plans, retirement plans, those also have beneficiary designations on them. Now remember, with pension plans, retirement plans, you have the IRSA problem. So revocation on death is not going to work for pension plans generally, because they're generally almost always going to be governed under IRSA. You're not going to have to know if they're governed under IRSA, it will tell you. So you don't have to make that distinction, you don't have to memorize the IRSA statute.
It'll tell you what the IRSA statute is.
Yeah. So they'll say in IRSA governed plan, in IRSA governed account. What does joint tenancy do?
It gives ownership to the surviving party.
It means that you both own a share of it. But upon death, it goes to your heirs rather than going to the other joint tenant.
No, not true. Joint tenancy will go to your surviving joint.
I thought that's joint ownership. Because they talked about it in this book. There was pages to be. I said 325.
Usually Randy does this. Should shut my mouth now.
It's 494.
What do we have to read this week in the white book?
265 to 319.
260.
So it's on 293, it looks like? Joint tenancy?
Is
That's
it?
an interest simply vanishes at death.
Or 292, 293?
No, it goes to the surviving person.
So you need to have the unit easement rule. We learned this back in, I forget what class.
Property rules.
Yeah.
First year. Was it first
No,
year?
Oh, yeah,
second
second year, yeah.
Oh, I was thinking of tenancy in common.
Right.
Yeah.
Tenancy in common wouldn't give you any survivorship rights.
Okay.
It's 494.
So you have a bank account in joint tenancy, girlfriend and boyfriend, girlfriend dies, who gets it? Boyfriend. You have a house, brother and sister, brother dies, who gets it? It's in joint tenancy.
Sister. Or whatever, Steve.
Whoever the surviving joint tenant is.
Correct. Does it have to say with right of survivorship?
Yes.
No,
No,
I think.
No,
Oh.
it doesn't. It's built into it. If you have the words joint tenant, that's an assumption that the surviving joint tenant is going to inherit. What's another way for two people to pass property in a similar fashion upon death? Yeah, community property with rights of survivorship. You gotta have that word though. Because community property just designates what type of property. If you say community property, you're not talking about the disposition upon death. You're classifying whether or not that property is going to have a community or a separate designation for purposes of a marriage.
The joint tenancy with your wife is more powerful than community property.
For transfer on death,
Mhm.
yes. For all other things, no. Because community property automatically gives you a step up in basis when your spouse dies. Joint tenancy doesn't do that. Now, you can have community property that's vested as a joint tenancy. So that's not like they're mutually exclusive. But if you have the word community property, it's unambiguous that it's community property. So the best case is community property with rights of survivorship. That will transfer upon death of one spouse to another.
And then if it's just community property, the surviving spouse would only get 50% of the deceased spouse's half.
No, the surviving spouse gets all of it, but it's not automatic.
Oh.
You'd have to go through some sort of court proceeding to get that 50% share.
Oh, okay.
So community property is, I already have my half of my community property, of the community property, and my husband's share of the community property goes to me, but I have to go through a proceeding to get it.
Oh, okay.
That's called a spousal property petition. Right? Now, there are some nuances, like some, institutions these days don't think that we need the words with right of survivorship, but for purposes of the bar exam, you will. Because the bar exam is not a title company, and they're not doing real estate. What about deeds? Can anybody think of a way to structure a deed that would transfer assets on death?
Yeah, it's like, owns it and then to my something.
What's that called?
Just give them a life estate.
Okay, that's one thing. So these are two different things. So go on the life estate first. That's what I was thinking of first.
The life estate is where you give it to somebody for their life, and then upon their death, they transfer it to somebody else.
Mm-hmm. But now you no longer have it under that scenario. I want to keep it. But when I automatically die, I don't want any probate proceeding. I want it to already be set up so that it transfers to somebody. How do I set that up?
Transfer on death.
Okay, that's something else.
Oh.
I'm talking about a life estate. Who would you give the life estate to under that scenario?
Yourself.
Correct.
You retain it.
Yeah, you could retain a life estate. So I can give my house to my daughter, but I retain a life estate. So now it's mine for my use while I'm alive, but my daughter automatically will get it upon my death.
But can you revoke a life estate? Like when we give it to your daughter in that scenario, can you take it away from her?
No, because I've given her a present value interest of it.
Yeah, exactly. So you can't sell it.
Correct.
Yeah.
So that's a problem. We don't like those, right? Because now I'm giving away my assets. But that is a way of doing it. Not done very frequently nowadays because nobody understands what the heck their life estate is. But that is one way of doing it. Another way of doing it is, let's say I want to give it to somebody, but I want a third party to do it to get the beneficial interest. It's what Vince was saying. You can give a life estate to somebody, and then upon that somebody's death, it goes to like a grandchild, for instance, right? Now it's no longer in my name though, so I no longer have any present value interest, and I don't have a life estate either, so it's completely out of my estate and out of my control, right? So that's another way of doing it. Now let's talk about a transfer on death deed. What does that do? By the way, the book's wrong. We do have them in California now. So the book says that we don't have them because this book was done in 2012. Next year, you won't be here, but next year you get a new book. So we do allow transfer on death deeds in California, and that is a probate code 5642. Now, these are new for California, so it's likely, I don't think it was on the exam in the last couple of years, so it's likely to hit the exam at some point now because it's a newer statute, it's only about 24 months old. So what does a transfer on death deed do?
It transfers it on death.
Yeah, so it's basically adding a beneficiary designation to a house or to real property. So basically you do this deed and it says, upon my death, I transferred so such property to XYZ. That is effective. When you die, that beneficiary just files an affidavit, death of owner, and it becomes their property in the same way that a joint tenancy would become their property when you prove that your joint tenant is dead. Lots of problems with this, right? Lots of problems. Subject to fraud, all kinds of fraud problems with this. Most estate planning attorneys hate this statute because it's ripe for fraud. There's so much fraud in real estate already. This is just one more thing. And if you file it, you have to, if you want to revoke it, you have to put another one on there. Or you have to physically revoke that transfer on death deed. Again, these are steps that people don't want to take to do it. You think changing beneficiary on a life insurance policy is hard. That's nothing. You go online, you download the form, you fax it back. Nothing like this for a real property. You have to file, you have to pay a filing fee, you have to go down to the recorder's office. So this type of a scenario is just raw for fraud. Also, in the statute in California, pretty much says if you're inheriting property under a transfer on death deed, you're assuming a lot of liability. Because you're assuming that if that decedent had creditors' claims, you may be subject to their creditors' claims. Because you accepted this piece of property, you accepted this asset outside of any probate process. So again, terrible, but they exist now. And again, since it's such a new statute, it's likely that it's going to start to show up on a bar exam.
So is giving it to someone while keeping life estate better to protect against creditors?
Yes, but no, I mean, yes and no. So no, in the sense that now I no longer have power over that. I can't revoke that. The transfer on death deed, you can't, right? So
You can't lose your power, but you have to trust the person, I guess.
you completely lose your powers to do whatever you want with the property. And what if you don't want to live there anymore? Well, the life estate doesn't transfer, right? A life estate is specific. So, you know, if you wanted to move and go somewhere else, that's not gonna help you. That the owner of that property doesn't have to necessarily give you a life estate in some subsequent property. Transfer on death deed, at least you retain a power to revoke while you have capacity again, obviously. Right? Okay. So this sort of the last bit about like the Shrivo and the disposition of bodies and healthcare. Unlikely you can even get a question about it because there's not much to it. We do now in California, unlike the book says, we also have a Physician Aid in Dying Act, but there's no way to plan for it. So there's not a way that you could possibly get it in a question because the statute is written in such a way that you can only make that designation at the time that you are terminally ill. You can't plan to make the designation in a future time. There's also a time period in that statute that says you have to ask for the drugs from a physician within a short period of time, 2 different occasions, witnessed by other people, et cetera, et cetera. So there's no way to codify and to pre-plan some physician in dying question, right? But we do have it. And there may be some sort of public policy argument. I don't know what it would be, but it does exist, unlike the book says. Okay? Disposition of body, we put those in healthcare directives. We don't put them in wills. That's under California practice. Organ donation, same thing. We put those in healthcare directives. We don't put those in wills. Shrivo is interesting, not that applicable. The Supreme Court of California isn't going to care, like the Supreme Court in Florida did. Your heirs can make a decision, and your agent under your healthcare directive has a lot of power. I mean, they're the ones who are going to direct the disposition of your assets. They're the ones who talk to the coroners. They're the ones who issue death certificates. They give the information to issue a death certificate. They are the ones who get access to HIPAA-protected information. Okay? So that's sort of the substantive arguments for will substitutes. Did you have any questions about that? Do you have any questions about this, the examples of what they are? It's, like I said, it's pretty self-explanatory. There's not that much archaic rules to follow. Like most of this stuff about deeds you've already done in probate. That's a lot of carryover there. Community property stuff, that's also a carryover. And it's not as, like I said, it's not as archaic as a will, the structure of how you create a will, how you revoke a will, how you do all of these things. It's either going to be a beneficiary designation, of which there can be a litany of them, and there's some ways to overcome those beneficiary designations. A major one is revocation on divorce, right?
I guess one big question I had, and it kind of relates to the question that Professor Burke gave us, is as far as like tax questions go.
Yes.
That, the way that I read the book was, if you're listed as a beneficiary, it becomes taxable. But if it's a joint ownership type thing,
there's no tax implications on it because you just succeed ownership?
That's not the way to look at it. It's the type of asset.
Okay.
So it doesn't matter what the sort of transfer of ownership is. It more matters what is the asset we're talking about.
Okay.
So beneficiary designations are usually for retirement accounts, pension plans. Those all have their own tax implications because they are tax deferred accounts. That's already built into that asset.
Mm-hmm.
Life insurance proceeds, not taxable, right?
Oh, they're not?
You inherit life insurance, that's not income.
Oh, I thought the book said that yeah, I don't know.
Again, tax deferred accounts are a totally separate thing. So if you're doing, let's say an IRA, for example, a traditional IRA. Now, if it's a Roth IRA, it's still a different beast.
Yeah.
Remember, because there's no taxes on the Roth. You've paid taxes already. You got your tax dollars. But the question is going to become, what is the type of asset we're talking about? Now, if you're getting income from an asset, that is taxable to you. Income is income. Whether you get it through a trust, you get it through a will, or what have you. Principal is not. You're not taxed on any principal. So let's say that there's a probate estate that lasts a year. And in that year, there's $100,000 of income. And you're the sole beneficiary. Great. So you have $100,000 of income that is going to flow through to you if you receive the entire estate within that 1 year. That's income though. So don't look at it in terms of what is the designation and how is that transferred, but what is the asset that I'm dealing with.
Okay.
That's going to be the major question.
Because in 13.5 it says, for example, life insurance proceeds on a policy owned by the decedent and payable to a named beneficiary are not part of the decedent's probate estate, but are usually part of the taxable estate.
That's federal estate tax. That's not.
So that's like the 50%, like over the 11.82?
Correct.
Okay.
So that's federal estate tax. Yes, anything in my estate when I die, essentially, is going to be part of my estate tax.
As far as if you're listed as a beneficiary, but if you're listed as a joint, is that kind of where that differentiation comes in? Where if you're a beneficiary, it's part of your tax estate, like the taxable estate, whereas if it's a joint ownership type thing, then it does not become part of the taxable estate because you just
because we don't know how much
ownership.
we don't know. No, it's not about that. It's about the accounts. We don't know how much money was put in by you versus you. So we don't know if I should take half of it and put it on my federal estate tax return or not. Again, it's the type of account, and it's the tax specifically. So that's federal estate tax. You're not like I said, you're not going to ever pay any income tax, inheritance tax, anything like that on pretty much anything that you get from an estate or a trust or a will in California. But life insurance is certainly included in your federal estate tax, that 11.2 plus threshold for estate tax purposes.
So they're not income tax, they are like death tax, the estate tax.
Yes.
Okay, I was way wrong on the midterm.
Well, the midterm isn't yet.
The practice question?
Yeah.
The practice one.
Yeah.
Yeah, sorry. Never mind.
That sounded weird, but
Yeah, practice test.
Yeah, so remember, your federal estate tax is going to go almost include just about anything.
Is that the same? I guess they had it was a joint ownership of a house. Does the half of the house become part of the taxable estate or no? Because that's a pretty even split. If it's a husband and wife, husband owns half, wife owns half. Does the half of the house that the husband owned, is that part of the taxable estate?
So I didn't read the question.
Okay.
So I'm not probably well versed to answer it.
It just says there's a $6 million house that was owned with rights of survivorship between the husband and wife. His half was valued at $3 million, and she wanted to know what part of his estate was taxable. Does his half of that $6 million house become part of like the federal estate tax? Or no, does it just transfer to the wife free and clear?
I think it would transfer to the wife free and clear, assuming it was just in joint tenancy.
Yeah, it says community property house with
Rights of survivorship.
That's what it says.
Yeah, in his estate, there's a house worth $6 million that he owns as community property with rights of survivorship.
So does she get the whole thing tax-free, like out of, like it just is not even part of the estate, it just gets moved right over?
I believe so.
That's what I thought.
That's what I thought. I was like,
I believe it would, because again, there's no way of necessarily, well, I guess she did tell you though that there's 3 million.
well, no, it just says that
she's right.
it's a $6 million house that he owns as community property with rights of survivorship.
So I think you just hand it over, right?
Well, you
Yeah.
definitely do for purposes of transfer, but
I just wasn't sure whether that was part of the taxable estate or not, because I was like, I figured if it's joint to survivorship, it just goes and you don't tax it because they just assume ownership of your half. It's not like it's being given to you. You already technically own it.
I think that's correct. I'd actually want to go back and look at the statute myself. Did Professor Burt review those yet?
No.
Well, not that she's given back to us
We
yet.
just got it last week.
Yeah, we sent it to her the day that she flew to Hawaii.
Yeah.
So I didn't expect her to.
But going back to the life insurance thing, because I just looked it up online because I didn't know, and it looked like the rule was that if there's an intended beneficiary that's not part of the estate, like you're going to give it to your son or nephew, whatever, then it's not part of the estate tax.
Yes, it is. It's
It
part of
still
your
is.
estate tax, but it's not part of your estate.
Okay.
So it's not going to be part of your probate. It's not going to be part of your will.
But
It's
it
not going
taxes
to
your
be
11.8.
exactly, but it gets to be brought back in for purposes of your estate tax.
Okay.
So yeah, it's nuanced. This federal estate tax problem is going to be a pain. It just is. I mean, because you have to bring in all of these different rules from various forms of tax law, from community property, from transfer property, regular property rules. Sorry. But it's just going to be that way.
You know, the tax pressures were the ones that I had the hardest with on that question because I'm like, I don't know the tax rules. Yeah.
So I would definitely recommend looking in, just doing a little refresher on, what's federal estate tax. When do I have to be worried about it? Again, marital deduction means you can pass anything to your spouse. So even if you had $40 million, for instance, you wanted to give it all to your spouse, you couldn't.
But you have to do that before you die, right?
No. You can do it at that.
So if you bequeath something to your wife in your will, that does not fall under the estate tax because it's a gift to your wife?
It does, but it is a marital deduction. So you don't pay any estate tax. Because you can deduct.
Oh, so it counts into your 11.8.
Yep.
But how do you determine what part of your estate falls below the 11.8 and what part of your estate falls above the 11.8?
Well, so in that example, all of it's above. So let's say it's 20. Okay, let's say it's 22 million. So half of it, essentially, for easy math purposes, is going to be taxed, technically. Okay. But you gave all of it to your spouse.
Mm-hmm.
So none of it you pay taxes on.
It's taxable, but it's deducted.
Correct. Just like on your income tax return. You owe, whatever the number is, $60,000. But you have deductions of $65,000. So you pay nothing.
Mm-hmm.
You have a refund under that scenario of $5,000. Same thing here. You have a taxable estate of 22 million, so your taxable estate is 11 million plus. But you don't pay any taxes because you got a deduction for giving it all to your spouse. Same result if you gave it to a charity. So a billionaire person with $100 billion dies and he has one beneficiary. And it's an animal rescue. No estate taxes are paid.
Wait, so why aren't you paying it on the top half? Like,
Because you gave it, because where did you give it? Where did you give it?
you give it to your spouse or to a charitable organization.
Yeah.
So
And those
is it a
have
special
specific-
deduction? Okay.
Yes. There's a marital deduction, which is just for your married people, and a charitable deduction.
Okay.
A litany of other deductions, but for the sake of what we need to worry about, Those are two that are very prevalent. Okay. Now, if you gave it to some normal person, no, there's no deduction there.
Right,
So you do have to pay a tax on it.
okay.
But say you have like a $22 million estate,
Mhm.
your house is only worth $6 million, and the rest is bank accounts and stuff like that.
Yeah.
That get given to other people.
Right.
So how do you determine like what went to your how do you claim? Can you still claim the marital deduction because you don't know? Only say $6 million of it went to your spouse, and the rest just goes to random people. So say your kids. So can you claim the marital deduction or can you not? Because you don't know which part of that $22 million estate falls below say, does the $6 million that went to your wife fall into the exemption of the 11.8, or can you claim the deduction on?
So you're only going to claim a deduction on whatever the above and beyond that federal exemption amount is.
Mhm.
So if that house isn't even included in my federal estate tax equation, then I can't include it as a marital deduction because my spouse didn't get any part of that federal estate tax problem.
Right, so
Right.
what I did is I knocked off 6 million and then knocked off the 11.2 and ended up with 5.8, and they got taxed on 5.8. That's what you guys did, right?
No.
I didn't read it.
Well, but, okay, if there's 22 million.
Oh,
and you knock off
I
6,
took off the 6, I took
and
off the 11
and then
point
you exempt
whatever.
11.2, you end up with 5.8.
Yeah, okay, yeah,
And they got taxed on 5.8.
something like that, yeah.
That's, I mean, I hope it's right.
Easy enough, whatever. that
Okay.
is,
Yeah.
And
Yeah,
then
the
the
7.82, the tax amount, well, because you didn't add in the life insurance.
No, I didn't.
So I added in life insurance, so I said the taxable estate 7.82 million because you take off the 11.18 million for the exclusion, and
So I was wrong with life insurance.
40% of that is whatever it is. 40% of that's 3 million, whatever, yeah. Too many numbers.
No. But unfortunately, it'll come back and bite you.
Yeah.
So who was the eventual beneficiary? Did they tell you?
The wife got the house, and she got $1 million. It was a $22 million. It says his total estate was $22 million. He had the $6 million house that he owns in community property with rights of survivorship with his wife. He also then leaves her $1 million and
So that's a marital deduction.
doesn't leave her anything else because she's independently wealthy. And then he leaves the rest of his estate to his 3 children in equal shares. In addition to his estate, he has life insurance that pays to his 3 children for a total of $3 million. And then it asks, how much is his total estate? So I was kind of confused because the very first sentence says his total estate is $22 million. But I wasn't sure whether I added in the $3 million that is in the life insurance policy as
So
part of
I guess you
the
don't.
estate.
You don't add that because it's not part of the estate, but then you do tax it because it's part of the taxable
No,
estate.
don't
right?
worry, you're using the word estate wrong.
I'm using the wrong case. Well, how,
She's talking, when she says the word estate, she means a tax list,
oh, okay.
not like a probate estate.
So they want, the insurance proceeds in there.
Insurance proceeds would be considered part of your taxable estate.
Okay.
Now, there would have been a
Because you said
million
total
dollars.
estate and taxable estate has different questions. Like 1 and 2 are completely different questions, right?
Yeah, because it says, question 1, how much is
You would
his,
deduct that 11.2 on the tax list.
question 1 is how much is his total estate?
Uh-huh.
Question 2 is how much is his taxable estate?
Right, so you would deduct that.
What about
11.
insurance though?
So would I not add the insurance into his total estate, but add the insurance into his taxable estate?
No. The taxable, I'm assuming what she wanted on the taxable estate is for you to understand what the exemption amount was.
Okay.
Okay. And then it said, and then question 3 is, what is the exemption for the estate tax purposes in 2018?
Right.
And then 4 is how much in estate taxes will be owed?
Right.
And then will there be a probate, and if so, on what assets? And then
So on that question on how much would be owed, you would want to be talking about the marital deduction.
we didn't learn about
No, I'm sure. You didn't know about it.
Yeah, no, I didn't. I just took out the 11.28 or whatever, the 11.18 million or whatever it is. Yeah, it's 11.18.
Yeah.
So I just took out that exemption. I was like, I don't know about any marital one.
Yeah, and that's not gonna, so the deductions isn't going to lower your taxable estate, it's gonna lower what taxes you owe,
Okay.
right? Because it's just like, think about it, are you familiar with your tax return?
No.
Everybody really looked at it?
No, I just do it on TurboTax and enter the information they tell me to.
Well, I want you to look at it. I'm serious. Look at it because these terms will become a little bit more familiar to you, especially if you look at previous years. Don't you look at 2018, obviously, because of the new tax rules are totally different. But if you look at your income tax return, you'll see Schedule A has deductions. So when you look on that first page of your income tax return, you'll see taxable amount, deductions, tax owed. So that's what this is kind of talking about.
Okay.
So it'll help you to sort of understand, okay, well, a deduction doesn't mean I lower my taxable amount. It just lowers whatever the taxes that I owe to the IRS,
Okay.
right? So I still have a taxable estate of whatever it was, 7.2, but I get a deduction, so I don't owe as much in the actual taxes I pay.
Okay.
So it would, yeah, so but the total amount, you count everything within the taxable amount, you do knock off the 11, right? Okay. And then deductions come.
Taxes owed is you knock off whatever the deductions are.
Okay, that's cool.
So do look at your income tax return. These numbers and these terms will become a little bit more familiar, and then you'll be able to sort of visually and conceptually understand, well, how does that even work? Well, that's how it works. So same, we have a $22 million estate and it's going to my animal rescue. So I owe taxes on 11.2 blah, 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 blah. But I have a deduction of 11.2 blah, 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 blah. So then I owe 0. Okay. So my taxable estate is the same amount, taxes owed is different. Okay, conceptually you want to think about it like that.
Oh.
Okay.
And the individuals aren't taxed, it comes out of the estate, right? So taxes are all done before proceeds are given out.
In the
correct?
best case scenario.
In the real world, or in the best case real world scenario?
In the best case real world scenario, yes. Now, sometimes that doesn't happen like that. So what happens is each beneficiary has to pay some sort of portion of, some prorated portion of the tax. So sometimes, yes, $22 million, I send a check of whatever the number is, let's say $5 million to the IRS. From there, I have 50% beneficiaries. Here you go.
Mm-hmm.
Great. Now, it always doesn't happen that way. Because sometimes there's a house. If the house is specifically bequeathed to somebody, how do I get cash out to pay them?
Mm-hmm.
So then that beneficiary, whoever inherited that, will have some pro rata share of the estate tax that they owe.
Okay. And you get some form from the court that's like, I already paid tax.
Not the court, because most of these are trusts.
Oh, okay.
Okay, so you wouldn't get anything from the court under that scenario because it's a trust. Okay. Any other questions about will substitutes or anything?
It's all very confusing.
Well, what part is confusing?
It's not
I mean, I know
that
you're making a general statement because it's 7:30 and
No,
it's a Wednesday, but.
No, it's just a lot to take in and remember.
Yeah, but this is kind of easy. This part is a little easier.
Yeah.
You're familiar with what a life insurance is.
Yeah.
You probably all have some sort of IRA or a retirement account. You probably all have seen bank accounts, joint accounts. You may have even seen the word POD.
Mm-hmm.
So what does POD mean?
Cable on that.
What does TOD mean?
Transferable.
Exactly. What does it do?
Hey,
Is it on that?
Exactly. Right? So pretty self-explanatory. You know, then what is that called? A will substitute. Why? Because you've sort of gone around all the requirements of having a will, which is transferring assets on your death, by virtue of some other mechanism. These are those other mechanisms. Now you're going to get into a lot more trust, because there's a whole chapter on trust. But for the most part, a trust is also a will substitute. It overcomes what a will would normally do: transfer assets when you're dead. Right? Okay. So next week is review. Bring questions. I don't know if Professor Ebert's going to email you anything beforehand. She, I think, has something to give you at that time, a practice kind of a question maybe. She probably will also be going over this with you. So if anything I said was wrong, sorry. And like I said, bring questions for her. Go back, review the stuff that we've already talked about. Look at your stuff from previous weeks. Anything that you're confused about, what does this mean? Things like redemption, abatement, what the hell are we talking about? Those types of things. Bring them back, and everybody can go over those together. And I'll tell her that you're doing that, so that she makes sure she brings all the source materials. Okay? All right. Well, let's go.
Thank you.
Thank you.
You're very welcome.
I love the fact that this class, you learn twice as much in like half the time.
We're pretty, as you can tell, we're pretty straightforward women. We like to just be cut to the point.
That's how it should be.
Yeah, let me think. Yeah.
Okay, and if you have questions before then, for whatever reason, I think you all have all of our emails, so you can email us, but otherwise, come prepared with questions. Come prepared with a little summary of what we've done before, from week 1 to now, so that you jot down, just like, your normal summaries are for questions and for your mini bar, et cetera. Bring that, start that, even if it's a rough draft, it doesn't have to be pretty comprehensive. But at least you'll have some sort of idea of what has been covered so far, and then you can go over them in a pretty thoughtful and concise manner. Okay?
Check.
All right.
Thank you.
Uh-huh.